It's Jeremy Matlow. I'm a city commissioner here in Tallahassee. I appreciate you all coming out here today as we try to beat the rain and get back into the sunshine. For the last 4 years, I've sounded the alarm about the lack of clear policies, accountability, and transparency as a Blueprint Intergovernmental Agency. The issues were on full display as we were all left scratching our heads on how a $27 million giveaway for stadium improvements even materialized, and then ran through the agenda ahead of other projects so quickly. We were perplexed when the Shamrock Road extension, which threatened to flood new traffic into Killearn, was proven to have no anticipated reduction in congestion and only serve a few hundred cars per day. Nevertheless, that project was expanded to more than $80 million in record speed. Routinely, we are asked why vanity projects and giveaways move to the front of the line while important, necessary projects like West Tharp Street, Orange Avenue, and the North Monroe Gateway continue to get pushed aside. Florida has broad public records laws. In theory, we should be able to trace the origins of these projects, their recommendations, and the entire decision-making process back to the beginning. But at Blueprint, that's not the case. Because Blueprint doesn't operate according to city and county policies. It prides itself on its one-of-a-kind structure not seen in other communities. That, however, does not excuse the agency from following the open meeting requirements of Florida law. Elected officials at Blueprint make top-level decisions on major projects, but the majority of the spending authority, contract approval, hiring decisions, and budget recommendations are delegated to the Intergovernmental Management Committee. This is the city manager and the county administrator serving on a committee. Why? Because it was decided that both of our governments needed to be represented in part of the decision-making process. However, the IMC doesn't issue any public notice when they need to speak or conduct public business. They don't keep official minutes, and there's no opportunity for public comment. The public is left completely in the dark on any conversations they have between each other related to Doak Campbell Stadium, the Northeast Gateway, or any of the other projects to come from this billion-dollar agency. The people of Leon County don't know what was discussed in the interview for the agency director because it wasn't conducted publicly. The IMC never discussed their applicants in the public, and the only public record we have about how the position was filled were through text messages revealed in the federal corruption trial. Today, in my personal capacity as a Leon County taxpayer, we are asking the court to provide relief and require the Intergovernmental Management Committee to notice its meetings, provide minutes, and not discuss Blueprint business outside of the sunshine. The last thing I want to be doing right now is suing our own government. But what other choice do we have? As an elected official, I exhausted my options. I requested we bring the Intergovernmental Agency under an inspector general. That was rejected. When concerns were raised about the IMC meeting outside of sunshine, I asked the board to ask the Attorney General for a written opinion, which her office routinely does. In an extraordinary move, that meeting was ended an hour and a half early to avoid the conversation. And then I asked the board attorney to provide a written opinion that I could provide to constituents on the way the IMC operates. It has been over 2 months since that request was made, and an opinion has not been issued. If I do anything with my time in Tallahassee, it's going to be to reform this broken system that works for the well-connected at the expense of everyone else. Having a clear understanding of how projects begin and move along in the process is a fundamental constitutional right that the people of Tallahassee under the law. And today, we are asking the court to affirm that right. Thank you. Joining me today is Attorney Marie Maddox, who can answer any legal questions on our behalf.
And on behalf of Mr. Matlow, we have filed a lawsuit, a complaint for declaratory judgment, asking that the court enter and declare that the IMC is in fact part of the Sunshine and has to operate inside the Sunshine laws. We're asking for injunctive relief, and the injunctive relief would require that they immediately comply with the Sunshine laws.
Are there any questions?
Yeah. Now, do you guys feel like the city manager and the county administrator are obviously making the decisions outside of the public's view, and this blueprint committee is just kind of approving them without the public's knowledge of what the issues are to begin with?
That's precisely what's happening. As a matter of fact, there are major project improvement decisions, money spent, that are decisions that are made, we believe, by the IMC, recommendations made to Blueprint, and those recommendations are followed. And they're actually, the IMC is actually making decisions itself, and the public has no idea what the basis is, why they've selected one company over another, and that is the focus of Mr. Matlow's complaint.
Marie, could this set some precedent for sunshine law? I mean, I looked through the citations that were noted in the lawsuit. There's not a lot of managerial structures similar to this around the state. Could this open a new layer of Florida sunshine law potentially?
I don't think so. I think if you look at the existing cases and look at the reason that they have, in these cases, have enforced the sunshine law and said that the sunshine law applies to committees that are very similar to the IMC, that I don't think you have to expand the law in order to include the IMC. There are not many folks that at least we've spoken with that believes that the IMC should operate outside of the sunshine.
My understanding is it's fairly common for the city manager and county administrator to meet to discuss issues that might impact both the city and county. Are you saying that any time they meet to discuss any issues, that should be open and in the sunshine?
No, and we tried to set that forth in the case law that we've cited. And it's when they're making recommendations, when they're making decisions. So just a simple conversation, no. That would likely not be covered. But there's a point at which they begin to affect decisions that are made about how money is spent, and that's what comes under the sunshine law.
Any other questions? All right. Well, so we can all stay dry. We appreciate you all coming out today, and we look forward to seeing this through. Thank you.